All right, so good afternoon again, everyone. Thank you for joining us for our RM 620 webinar. My name is Avalon Powell, and I am the Marketing and Event Coordinator for Braun Gresham. A couple of things to note before we kick off here. We encourage you to ask your questions throughout the webinar. You can submit those one of two ways. First, if you scroll over the Zoom screen, you should see a toolbar at the bottom of the page. There is a Q&A option. You can select that and it will actually open up a separate window where you can submit those questions. The second option on that same toolbar is a chat box. You can also select it and it will open up a separate window for you to message all of the panelists. Again, please do submit those questions as we go through this presentation, and we're happy to address those as they come up. We will be recording the webinar today, and I will share that with you and the slides. I encourage you to please share those with your neighbors and your RM 620 community. If they have any questions, they're welcome to reach out to us as well. Today, you will be hearing from attorney Patrick Reznik of Braun Gresham. Patrick's clients are primarily landowners. His Texas farm and ranch background, agricultural engineering education, and hardworking lifestyle bring a skilled, creative, understanding, and compassionate approach to protecting clients' rights and resolving conflicts. His years of working with clients in difficult and often emotional circumstances have equipped him to handle complex legal problems with skill and compassion. A large part of Patrick's practice is representing landowners in eminent domain or condemnation matters. And Patrick, feel free to take it away.
Thank you very much, Avalon. Good evening, everyone. Thank you so much for joining. Avalon, can you hear me okay?
I can hear you fine.
Excellent. And can you see the slide?
I can, yes.
The evening will take about 45 minutes. And as Avalon mentioned, please ask your questions as we go along. This is very informal. It's meant to be very informative for you as landowners. Not only if you have property on 620, or if you have other properties that may be impacted by a governmental agency or private company who is wanting to take some of your property. What I'd like to do is discuss basically the agenda for this evening, and that will be talking about what we know about the 620 project. If you have any other information than what we have, please share that. We would like to have that additional information so that we can share that with others. I want to talk about some of the legal terms and the law related to eminent domain or condemnations, the various steps in condemnation, how to negotiate these, and whether or not you need an attorney or experts, a team to help you out. A few examples, and then again, we'll have questions at the end, but please feel free to ask questions throughout this process. So I want to focus on 620 between 71 and 183.45. I know there are some areas closer to I-35 that are planned to be expanded. This is a map that we received from, or that you can obtain online with TxDOT and their website. And look at the bottom, you can see the red areas are those areas that are scheduled to be constructed sooner than later. The blue is much further into the years. One of the problems with the TxDOT and these projects is timing. We have no way to know for sure when a project is going to move forward. Oftentimes we find out from our existing clients who say, hey, I just got contact from the right-of-way agent. They're now saying this project is moving forward. They have funding, and time is of the essence. You hear that a lot. Time is of the essence. And they may have been waiting for 2 or 3 years for something to happen, and now time is of the essence, and they want to hurry up and negotiate a deal. This is a complicated process. Right now with 620, what we know is that some landowners are being contacted by either TxDOT representatives or sometimes the City of Lakeway representatives. TxDOT hires agencies that are third-party agencies in order to work with landowners in order to hopefully come up with a resolution and primarily compensation on the land that's being taken. Right now, we don't know of any firm offers, certainly not any legal proceedings that are going forward. So if y'all have different information than we do, please let us know. As I mentioned, if you go to the website for TxDOT, it looks apparent and looks obvious and it looks transparent, but it's really not. You have to really dig down deep to find information, and quite frankly, all the information is not there. They'll give projected dates of starts, but those can change dramatically. I have a case south of College Ride Station that's been going on for 4 years, and they keep starting the project, delaying the project, starting the project, delaying the project. I don't think the COVID-19 is going to have much impact on the delay of TxDOT projects and highway projects. It may actually move those cases forward because the infrastructure is needed, even though people aren't driving as much. It's a good opportunity for TxDOT and other agencies in order to move forward. And I think those will be considered essential projects, and the funding will continue to come forward. So I don't expect any delays, quite frankly, on these projects. I want to talk about some of the terminology that we'll be discussing this evening. First of all, what is eminent domain, and what's the difference between that and condemnation? Eminent domain is the power that TxDOT or even private companies such as oil and gas companies have in order to take people's property against their consent and force an easement or force a take in order to build new infrastructure, whether it's a road, whether it's a school, whether it's a convention center, whether it's oil and gas pipeline, whether it's a water line. They have the power of eminent domain, and it's given to them either through statute, through the state, or through federal government in order to force landowners to give up their land for additional purpose that's supposed to be for a public use. And I'll discuss more of those laws here in a second. Condemnation is the process that they go through in order to condemn and take people's property. So they have eminent domain authority to condemn the property. Two key parts of terminology is the part taken, which is red, and the remainder. So the part taken, if it's a TxDOT project, they're going to take the land and they're going to take it in fee, which means they're going to own it. It's not an easement. A transmission line company or a pipeline company or a water line company are going to take an easement. What that means is that they're going to take rights to the property, but you still own the property. Fee means you do not own the property. It's deeded over to, say, TxDOT or to the city of Lakeway or whoever is going to be doing the project. An easement means you still own the property, you still pay taxes on the property, but you cannot build or use the property for lots of different things. You can still use it for utilities and things like that, but you're very limited in the use. So the value of that property is diminished dramatically. When it's taken, and especially if this red is a commercial piece of property, that part is taken, you should get commercial value for that property. And then maybe, or maybe not, depending on the situation, you may have on the remainder portion of your property some additional commercial space. So the remaining portion of the property, or the remainder, is what's left of your property after the take. So two key terms are what is taken, what is the remainder. Is this taken in fee, or is it taken in an easement where you still own the property? So those are very important terms. It's used in condemnation proceedings, and it's important for you to know the differences. A lot of times TxDOT will say, well, we're taking a right-of-way. Well, right-of-way oftentimes means in other situations, well, they're taking an easement. Well, they're not. They're actually taking the fee of the land so they can build a new right-of-way, highway or road or access or whatever it may be. Just a general area of the law and where this comes from. First of all, it's the Fifth Amendment of the U.S. Constitution. Governments can take citizens' land, that private property, for public use, but they have to compensate the citizens for that. Texas Constitution talks about what's adequate compensation, and there lies the big distinction between, what is adequate compensation between what the government is taking or what a pipeline, which could be a private company, is taking, and what the landowner feels like adequate compensation is. All I do is represent landowners in the state of Texas. don't represent condemning authorities or companies who are taking my clients' lands. Our firm is based in the state of Texas, and we represent landowners all over the state who have land and are trying to maximize the benefits of those properties and protect their property rights in the state of Texas. And we feel very differently a lot of times on what's adequate compensation as compared to the condemning authorities. Chapter 21 of the Texas Property Code is the statutory provision that dictates what is required in order for them to go through the process of condemnation and take people's properties. A lot of times people think, well, I don't want to be condemned, therefore let's work something out. Well, if you're contacted by a condemning authority about taking your land, whether it's to survey or whether it's to have an initial discussion, you're in the condemnation process right there, even so though some of the formalities have not taken place. So a lot of times they will say, well, we don't want to condemn you, but the reality is that they already are in the condemnation process. I want to do an example right now of the things to be considering. This is HEB off of 620. I think everybody knows, so who's familiar with this area, where the HEB is and where the parking lot. Here's 620. This is a property that's right across 620 from HEB, and it's been there for quite some time. The orange is what we believe is going to be the taking, as we talked about, of the right-of-way or the in-fee ownership of the property. So the question is, what is the impact going to be to that property, and how do you look at what the potential damages may be or what you should be doing? I'm going to move to the Google Maps and show you what that looks like, so we can kind of zoom in and look at what this looks like from if you were to own this property's perspective. So you can see here is HEB, here's the parking lot, here's Glen Heather Drive, which is an intersection that has become very, very, very busy. If you zoom out, you can see all of these new subdivisions, these new homes are being built. And the only way to get to those primarily is through one of these access points off of 620. And this is one of the main areas that are being utilized now. So as that grows, the traffic in this area is going to continue. The property here is some commercial buildings that have various businesses in those. Those buildings have been there for quite some time. So the question becomes, well, if the TxDOT and City of Lakeway are going to be taking this portion and this portion of trees along the frontage, what does that mean for the rest of my property? And can I continue to use my property as I've been using it now? And those are questions that you should be asking with TxDOT, with the City of Lakeway, because you have all these utilities that are along the right-of-way here. If they expand the highway and take this area and these trees here, these utilities are going to have to be moved over. Well, this parking area here for employees is going to be reduced in size. And right now, this is impervious, is pervious cover. Right here is where the employees or customers can park. This is employee only. Right here is impervious cover. What's going to happen when this area is taken, this is reduced, and what's going to happen with this particular intersection? The city, I think, is looking to expand this sort of intersection, put a different control system here, maybe take out this medium, maybe take out the signage that's here. The question is, well, how do I access this property? If you're going to change this, am I still going to have direct access from here? Right now, you turn from Glen Heather onto this particular property in the front for the employees to park. There is no direct access from 620. Is TxDOT going to give this property owner a direct access from 620 so that they have a curb cut somewhere along this line so they can actually use this as additional parking? And those are good questions and questions that need to be answered. And then if there's a city going to give them any variances, because if they've maximized their impervious cover and they're taking out this landscape coverage that's here, what's the impact to the remaining portion of the property? Are they going to have to use some of this property for additional landscaping? Are they going to have to reduce the amount of impervious cover? I don't believe the buildings are going to be taken in this scenario, but what is the access going to be look like, and how many people are going to be able to park in this area, which impacts the type of business that one has depending on the number of parking spaces. And city zonings usually require a certain amount of parking spaces for depending on the type of business. Are they going to give a variance or allow them to be, quote, grandfathered in case this is being reduced? So a certain amount of entitlements that are not directly compensable should be discussed as far as what's the value of the remaining portion of the property after this particular property is taken. So every property is unique and every situation is different, but these are questions that landowners need to be asking TxDOT and the city of like, okay, what are you going to be able to do for my, after you take this additional property from me? What am I left with, and what are my rights, and what are my limitations? And if they won't give you clear answers in writing, then that's something that we have to take in consideration is what's the worst case scenario. If this property has to be redeveloped, is there going to be a detention pond that's going to be required, or a water treatment pond with runoff, depending on where the runoff goes and where the aquifers are. If you have to put a detention pond in, then that's going to reduce the amount of land that you have to build on, either for buildings or for impervious cover for parking. And it's expensive to put those particular things in. So is the city going to allow you, or TCEQ going to allow you, that's the Texas Commission on Environmental Quality, allow you to avoid having to build a detention pond? Those are questions that are good questions that need to be asked from the landowner. And that's information that, quite frankly, is not freely available from TxDOT or the other agencies who are in this process. What they're very focused on is to hurry up and get the right-of-way acquired, get the landowner paid, and move on to building the project. So I'm going to move back to this slide. If there's any questions, please ask Avalon. If not, I want to kind of go through the general process of condemnation. There's basically 4 phases, as I call them. First phase is when you get some sort of call or possibly a letter from a representative. We often call them landmen. They could be men or women, but they go by landman, that says we would like to survey the property. That's something that they have a right to do. If you prevent that from happening, then they can go to court and get an injunction and force you to allow them to survey. So for my clients, I have a right of entry agreement that I like to enter into that gives my clients as landowners more protections, and we allow them to go ahead and do the survey. And I'm going to talk about each one of these in a little bit more detail. Second phase is, kind of what terms can you negotiate depending on what's being taken and how much money are they going to pay you. Third is what's called the special commissioner's hearing, and that is if you haven't negotiated something beforehand, then the petition is filed and commissioners are appointed. And after that, you end up in district court or county court at law, which is a regular trial proceeding if something hasn't been resolved before then. So let's look at each one of these phases a little bit more detail. Again, this is the guy in the blue shirt is a friendly guy meeting with the landowner who has obviously a farm. They may be putting a pipeline or a transmission line or a water line, and they're going to say, hey, we're just trying to help you out. We want to make sure you get the most compensation that you can. Let's cooperate. And again, if you don't cooperate and you refuse to allow the survey of the property, then they can go to court. But remember that the right-of-way agent or the landman works for the company who's condemning your property. So that's where their loyalties lie, and that's where their interests lie. If nothing is negotiated and you don't feel like the offer is sufficient enough, then what happens is a written offer comes. We often see the first offer is quite low as far as our opinions are concerned when we look at adequate compensation. And if it's an easement, we don't think the easement terms are very sufficient. As we were talking about with the example that I was mentioning, what about all the other issues that are related to the property's use? So things need to be discussed, not only just compensation, but the use of the land, or their buildings can be taken, what's the impact to the remainder, driveway cuts, city entitlements on the remainder after there's taking, because you may be in what we call allowable non-compliance, but if the TxDOT takes the property, you may be in disallowable compliance, and that may change what's required from a city use standpoint. The initial offer that comes in under the Texas Property Code, Chapter 21, as I mentioned, requires a bona fide offer. That's an initial offer, and it requires that offer to allow 30 days. Sometimes the offer, say we'll give an offer of $10,000. Sometimes it will say you have 30 days to respond. Sometimes it will give you a date that you have to respond, which will be 30 days out. Sometimes it doesn't say anything about a response date, but they have to allow you 30 days before they issue what's called the final offer. So after this property code deadline of 30 days, they send a final offer, which gives you 14 days to respond. That can be very concerning for people. I just got a call from a client today who got their 14-day final offer. And even though we'd had this discussion, they were in a panic because they were saying, oh my gosh, we only have 14 days to answer. And I reminded them that the only reason it says 14 days is because that's what the property code requires. And you get that and said, and it's only 14 days, you have to make a decision. It can be very stressful for landowners. Even though you've been prepared for this and it's coming in, and sometimes the final offer is less than the 30-day offer. Sometimes it's more, sometimes it's the same. But regardless, during this process, you're required to receive an appraisal from the condemning authority, which gives you a basis for their amounts. I have seen some pretty awful appraisals come from the condemning authorities that give very, very low numbers. For example, today the appraisal was at $10,000. Their initial offer was a little bit over $11,000, and then the final offer was a little over $12,000. All those numbers to me are very, very low for the taking of what's happening to this particular property. But there are appraisers that work for the utility companies, for TxDOT, whose job is to work up an appraisal in satisfaction of their client. And oftentimes the numbers are pretty low. Sometimes they're not. And my job is to look at the offers, look at what's being taken, look at the remaining portion of the property, and give my clients an opinion on whether or not I think it's a fair offer, and whether it's adequate compensation under the U.S. Texas constitutions, or whether it's not. And do basically what's called a business analysis, because if you don't accept their offers or negotiate something that is higher, that's acceptable, then you're looking at going into some expenses with attorney fees and with experts. And that's a business decision that has to be made. Because at the third phase, if no negotiations have come to a resolution and a settlement, then a lawsuit is filed. That's called a petition and condemnation. And so, yes, it's a lawsuit. It'll have the state of Texas. If it's a TxDOT case, it'll have the property owner's name. And you're sued. It could be served at any time of the day, and generally it's not late at night, but sometimes the process servers get those over to the landowners at a very unreasonable time to get them served, which is unfortunate. I always tell them I'm willing to accept the service of the petition for my clients, and sometimes they allow that, and sometimes they don't. I don't have any control over that, and the court doesn't have any control over that, because the lawsuit has just been filed, and the service of the lawsuit has to be made. What happens next? Well, if you haven't negotiated a settlement, then the judge, where the case is filed, that judge appoints 3 resident landowners. Now, the special commissioners have nothing to do with the county commissioners. the county judge. These are appointed by the judge to be special commissioners, which means they have to be landowners in the county. 620, this is a Travis County project, so they have to be landowners and resident landowners. They actually have to live in Travis County. So own land of any size and live in Travis County, and they could be appointed as special commissioners. Many times they're commissioners who have knowledge of real estate. They may be brokers, they may be realtors, they may be real estate lawyers. They could be appraisers. It could be anybody. They don't have to have special knowledge, but a lot of times the judges do appoint people that have a little bit more experience in real estate than somebody that doesn't. And the purpose of this hearing is for the commissioners to hear the testimony from the appraiser from TxDOT, from the landowner, and the landowner has an appraiser, the landowner's appraiser, and their job is to decide compensation. They'll decide, well, has the offers been too low and the appraiser's too low from TxDOT standpoint, and it should be a lot more. Sometimes those differences can be in the tens or hundreds of thousands of dollars. Sometimes it could be in $1 million difference. Just depends on the taking, the damages to remainder, and just the properties, the use. Now, why do we have this process? Well, the law has this process because there's an administrative process that has to happen before the condemning authority has what's called the right of possession. This right of possession means once they have a hearing, the commissioners deposit or award amount of money, then the condemning authority deposits that amount of money in the registry of the court. Then once that happens, under the law, they have the right of possession, which means they have the right to construct. So even though you haven't settled on compensation, once you go to one of these hearings, the money's deposited, they can start tearing down buildings, they can start building the road. They have complete access to the property in order to start building the infrastructure, even though you haven't settled on compensation. Now, what if the amount of money is satisfactory to the landowner? Well, the condemning authority may say it's too much. They can object to the award and they can appeal. The landowner may say, oh my gosh, the commissioners awarded such a small amount, that's not enough. Well, the landowner can object to the award and appeal that. And then it goes to the district court or the county court at law, wherever the case is filed. And at that point in time, it's a regular case before a jury or a judge. And the rules of evidence apply, the rules of procedure apply. It's very technical. The Supreme Court decisions apply. So I never recommend a landowner go through this process without an attorney at this level. And because the rules of evidence apply, it's highly technical. If you look at phase 3 through the special commissioners, a lot of times landowners go by themselves and just see what happens. And then they hire a landowner at this point if it doesn't go well. I still recommend that if you're going to do this, you need to go to the commissioners with data to show why you think the compensation offered is too low. You need to have what we call comps on land sales to say, listen, they value the land at too little. This is the impact it's going to be having on my property. This is the kind of money I'm going to be losing. I can't use the property for these things anymore. Therefore, I should be entitled to a lot more money. I still recommend if you go to these hearings that you do have an attorney, that you do have some experts that can help. And they could be one or more. But once you're at this level, it can get quite expensive because you've got depositions, you've got hearings, and you've got a lot more legal time that happens at this level. So this discussion here on phase 2 and here on phase 3 related to what is the offer, how good is it, is it worth the risk of going forward and having to end up at this phase 4. Those are discussions that really need to be had so that you know and making good decisions and getting through that process. So what does it mean when my land is taken? How do you value that? The Texas Supreme Court has simplified it to some degree. And what that means is, what is the total compensation that I'm entitled to? What is the value of my land before the taking? And what is the value of my land after the taking? So what's the value of the take? What's the value of the remainder after? But what we do now is we lump it all together and just say, let's look at the land value before and the land value after. And that delta or that difference is what we believe is adequate compensation from the landowner standpoint. Here's an example. Now, this is not a TxDOT case. This is a real life example that was a jury trial I did a couple of years ago. It was a transmission line up in North Texas. And this is our appraiser's number, $319,000. And this is two ways of looking at the same number. When you look at what I was talking about, this, what's before and after, that's what this first analysis is. The market value of the land and the improvements, the homes, the barns, and things like that. So the whole value of the property is $1.5 million. And then after the taking, the appraiser says, it's worth 1.2. The difference is $319,000. Another analysis that can be done to get to the same point is, what is the easement acquisition? Since it's a transmission line, they still own the property. What is the temporary construction? What's going to be taken for 18 months or so during construction, then is given back to the landowner. And what's the value of the remainder, as we talked about? The remainder is devalued 20% because the property without a transmission line is worth 20% more than a property with a transmission line. So you get to this same $319,000. So the reason I bring this up is because a lot of times the companies will look at, well, let's just look at the value of the acquisition. There's no damages to the remainder. So really, we'll give you the $9,900 and the $3,400. So, we'll since you give you, $13,000 and call it a day. And we're going, no, the whole property is impacted. And that's how we do that analysis. So in this real life example, we went to a jury trial. The utility company said the total damages are, $36,622. We presented to the jury $319,247. So you can see the numbers can be substantially different because of the appraisal methodology. And you add a 0 to this and a 0 to this, and you're looking at significant differences, in the numbers. So it's important to look at what the analysis is, what the damage potentially may be, and is it worth going this far, like we did in this case, to a jury to award compensation because the utility company would not offer what we considered was adequate compensation. The successful negotiations depend on a lot of things. One is, as I was talking about with the example on 620, is start thinking about what are the impacts? What is your wish list? What do you think the compensation should be for the taking? What's the impacts to the property? What entitlements may be taken away, or what entitlements can you preserve with the city or the zoning and things like that. Oftentimes we have landowners who contact their neighbors, and we have a coalition of landowners. While every property is different and the damage to each property is different, if we have a coalition of landowners, I find that it oftentimes gives us leverage, because we may have 4 or 5 landowners in a particular area. We can negotiate simultaneously in order to try to get greater compensation for everybody. The sense being that if the condemning authority can settle, 5 cases rather than just 1 case, that may have value to them. The other is, what type of professional team do you need? And that can include a lawyer, it can include other experts. Appraisers are probably the most common. I've got a case right now in Cedar Park where I've got an appraiser. We've had to hire a land planner. We believe there's going to be a detention pond and a water quality pond that's going to be required to be built. I have to have an engineer to design that, give us a cost estimate of that. Plus the business is going to be taken down, it's going to be raised, and what is the value of those buildings from a depreciated standpoint. So in this particular case, we're going to have at least four experts that are going to be looking at this particular project. Not every project certainly is that complicated, and some don't even need appraisers. Sometimes you can get something negotiated without having to go to these other expenses. But there are things to consider, and there are things to look at when you're deciding what you're going to decide, because if a condemning authority is taking your property, it's a one-time compensation. Whether it's an easement or whether they're taking it in fee, you get paid one time, and that's it. A lot of times people ask about pipelines, oil and gas pipelines, water pipelines, transmission lines. Don't I get paid a royalty for the amount of water or gas or petroleum or electricity that crosses the property? And the answer is no. Under the current state of laws of Texas, they condemn your property, they pay you for the devaluation of the property, which is in dispute, and that's it. Then they're on your property for the rest of the utility company, or TxDOT takes it in fee and they own the property, and they start paying the taxes on the property, and you're done. A lot of times clients or potential clients ask about, well, what's this going to cost me? And that's a decision that the client and the attorney needs to make. I always consider a fee agreement to be a negotiable item. This is not something that you just accept what the attorney offers. You have options, and you need to consider those options. Two of the biggest options in these type of cases are whether you take it on a contingency fee or an hourly. If it's a contingency, that means you don't pay anything up front. Typically, it's a 30 to 40% difference in the increase in what is offered and what is obtained, meaning if the offer is $1,000 and obtain a $4,000, that $3,000 difference is subject to the contingency fee that we've agreed to. There are no expenses such as travel expenses or meals or lodging or anything of that nature, or copies, anything that sometimes people hear about. The only expense that could be is if we have to hire an expert, and that is a landowner expense. Whether it's an appraiser or other experts, that would be the out-of-pocket expense. Otherwise, on a contingency fee, we handle all negotiations, any hearings, any trial under that fee agreement. If the client prefers an hourly, then it's paid by the hour. A retainer is required to go into the client's trust account, and then you get monthly bills, and you pay monthly legal bills. And if any expert appraiser is retained by agreement between the landowner and the attorney, then you pay that. But all negotiations, hearings, and trials are all paid by the hour. So whatever time the attorney spends per hour is what's paid. And usually those are in 1/10 of an hour increments from most law firms. On a contingency fee, it doesn't matter how many hours they spend on it. The percentage is the same. That is the presentation. I really appreciate you staying with me and listening. And if you have any questions, please ask those now, or you can contact me through this email address, or this is my phone number. Even though we're not working at the office right now, this will go to my voicemail, and I will get that. And we'll make sure Audrey, my paralegal, Avalon, who is on the call now, or I will return your call and schedule a time to visit more. We provide free consultations, so we can do one-on-one, look at your particular property, and assess what the impact may be, and start brainstorming now and start developing that wish list that I talked about. Two of the things I'd like to talk about is if you're interested in landowner rights, Trade Coalition is a bipartisan landowner organization comprised of landowners on the board who are advocating for landowner rights. They've been very involved in the Kinder Morgan Permian Highway Pipeline project that's been going through the Texas Hill Country, and they've been very great advocates as far as for landowners on those processes. So that's that information. Membership is free. Of course, you can donate if you want. Another is our landowner alert system. We call it the LAS, but it's an email that goes out twice a month. It has embedded in it 2 or 4 links on landowner issues that you can look at. Click on if it's something that you're interested in, delete if it's something that you're not. Just go to braungresham.com and subscribe there. Of course, it's free, and we don't use it to solicit or anything of that nature. But you can send questions and inquiries, through that system as well if you're interested. So I would encourage you to subscribe to that if that's something that you would like to stay informed about as far as what's going on in the state of Texas, in particular, TRED, landowner rights. And then again, here's my email and contact information. And Avalon will come on and kind of do some follow-up about what she's going to do. And again, if you have any questions, go ahead and send those to Avalon, and we'll answer those right now.
And we do have a question, Patrick. If you have an easement on your land and now they are coming back to work on it, is there any compensation that can be discussed?
If you have an easement on your property and the easement holder, let's say there's a wastewater line easement on your property, and the wastewater line, it needs to be maintained. The answer generally is no. If they're only staying on their easement, let's say it's a 30-foot easement, and they're maintaining that easement, or they're doing work on that easement, even digging in that easement to maintain whatever infrastructure is there, the answer is generally no. What dictates that is what is the language in the easement. If you have a piece of property with easements, you should have copies of those easements so you know what the easement holder's rights and limitations are, as well as what your limitations are. If they're going to expand the easement, say from 30 feet to 50 feet, then yes, they would have to pay you and condemn if they had to for that additional 20 feet. But the easement language is really what dictates that.
Thank you. And I haven't seen any other questions come through, but if you joined us late, if you'll just scroll over your main screen, you'll see a toolbar down at the bottom. You can submit your questions through the Q&A or chat box. You can select either one of those on that toolbar and just type them in. And I'll give y'all a few minutes to do that. Just as a follow-up, I will be sending out an email tomorrow morning that will include a link to this webinar presentation. I encourage you to share with your neighbors and RM620 community. You are welcome to share my contact information with them, and we can also address any questions they may have. I will also be sharing the webinar PowerPoint. So if you need this link to Patrick's email, or if you'd like the link to the TRED website or our LAS newsletter, you can find it there.
Thank you, Avalon. And I'll add that any input that you have as far as this presentation, normally we like to do these in a setting where we're actually meeting one another in a conference room or something of that nature. But given the current situation, we're doing more of these webinars. And any information that you have, any comments, any feedback as far as how productive it was, how informative it was, what other information you would like to see or that you didn't get to see, you loved it, whatever, please provide us that feedback, because it'll really help us. I did try to keep it to 45 minutes, and so we're bad on mark on that, because I know your time is valuable. Maybe I'll talk too fast and we should expand it to an hour. So any comments that you have are very, very welcome.
We have one more question, Patrick. Yeah. When you go to any hearings, is that generally with the client in attendance?
Absolutely. I always want to have my clients, if they're interested, I do. I have had situations where my clients were so adverse to having to be in those sort of settings, just uncomfortable, that they just said, Patrick, you handle it. But I always encourage my clients to be at any of these proceedings. We just had a condemnation hearing last Thursday in San Antonio. The judge handled it through the Zoom, and both of my clients were there. And it was interesting because they were very comfortable and just started talking to the judge, and the judge says, well, I believe you have your attorney here, so let's have your attorney speak, and you're represented. So absolutely, yes, I want my clients there. I want them to be an integral part of the process, so that they see what's happening and they can ask questions during the process. Especially oftentimes during some of these special commissioners hearings, there's a lot of things that may come up because the client landowner has intimate details of the property that maybe something has been missed, and they can pass me a note or whisper in my ear going, hey, what about this? And that's always helpful. I always learn from my clients on these processes.
Great. Thank you, Patrick. All right. And if there's no more questions, everybody, I'm going to go ahead and shut this down. Please do keep an eye out for my follow-up email, and you're welcome to respond and ask me any questions you may have, and I can also connect you with Patrick.
Thank you all very much. Appreciate your attendance and attention, and thank you, Avalon. Y'all have a good night.
You too.